I just want to talk to you a little bit about this mysterious probate process. What's really involved here? I can speak only to California courts. I practice all over Southern California. I have different experience in the different superior courts in different counties, but I can tell you, very generally the process here. When we see that somebody needs to set up a probate case, we're talking about a scenario where somebody dies with just a will, or if they die with no will or no trust, no documents, then we're talking about a type of estate we call an intestate estate. And so we'll still need to go through the probate process. And essentially we identify the person who is willing to act as the personal representative, whether that person is the executor named within the will, or if we have a close family member who is identifiable as an administrator who is willing to handle the probate case where somebody has no will. That individual has to file an initial document called a petition with the local probate court. The court will set a hearing date, roughly 6 weeks out, and working towards that hearing date, that person, usually working with an attorney, will then work through certain requirements to make sure they are formally appointed at the first hearing 4 to 6 weeks later. We talk about a publication requirement where a local newspaper must publish the notice of the probate hearing and give the specifics regarding that date so that the general public is made aware of this probate hearing date. At the first hearing, barring any kind of challenges or objections by anybody who may object to the appointment, then that person is appointed by the court, and that starts the process going, where the person then has to deal with the specifics of making sure that the person's last debts are paid and honored, making sure that assets are identified and marshaled. Assets then have to be appraised, and that involves the services of an outside appraiser who is appointed by the court. And that person, we identify them in common terms as an appraiser, but the court identifies that person as a probate referee. That person has to appraise all real property and any assets that are not tangible assets. They're not easily quantifiable, like stocks, cars, valuable collections like coin collections, that kind of thing. All of those items have to be appraised and documents filed with the court to identify what those assets are so that everybody is aware of what the assets are. Then we have to make sure that enough time has passed so that all creditors have the right to make claims against the estate. And after that point, we know we're past that point, then the person has to make sure that assets are liquidated, reduced into an account and available for distribution to the beneficiaries, whoever they may be. The final step that needs to be taken inside of a probate case is filing another petition that is an accounting report and that identifies for the court what the assets are, what income has come into the estate, what expenses have been paid by the estate, what's left in the estate for distribution. And that petition is sent out, it's served upon all parties of interest here, which would include all beneficiaries, and they would have in turn a right to object if they feel that all the information is not accurate or complete. But setting that petition up for a final hearing, then the court would review all of the paperwork filed with the petition, would bless the petition at some point, and allow the personal representative to distribute the assets to the rightful heirs. So we're talking about a process in the best light is 6 months, and oftentimes extends beyond 12 months. So also what should be known about the probate process is that typically there's a statutory fee that is paid to the personal representative, and that is set under California law, depending on what the value of the assets are. And there's a percentage scheme that's identifiable that tells us that the personal representative is paid this way, and the attorney representing the personal representative is also paid an identical fee. So to give you an idea, just an overall idea of what this fee is, if we have $1 million estate in California that must go through probate, we're talking about a translated fee, a statutory fee payable to the attorney and to the personal representative of $23,000 to each. So right off the bat, you're talking about $46,000 in statutory fees that are payable. On top of that, you have court filing fees, you have the newspaper publication fee, the fee payable to the appraiser or probate referee, and miscellaneous expenses that will take that cost of the overall probate process over $50,000. Those expenses could be easily avoided if the person had prepared a will and a trust. I'll get into the discussion about a trust in later conversations, but I just wanted to give you the outlay of what happens in probate, just to give you an overview. Thanks so much for joining me.